Committee on Justice and Human Rights. Pursuant to the order of reference of Thursday, March 13th, the committee is meeting to study Bill C5, an act to amend the Criminal Code and Control Drugs and Substances Act. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. I would now like to welcome all the witnesses, but before I begin, I just want to let you know I'll be waving a green folder when there's 30 seconds remaining in your time. And today I have a black card that I'll wave just to tell you your time's ended. Hopefully I won't have to interrupt you, but just be mindful of that. And the same goes for the members. Each witness will have 5 minutes for their opening statements, and then there'll be a round of witnesses. So I'll begin by Mr. Stéphane Wall, the supervisor retired from Service de Police de la Ville de Montréal. So over to you, Mr. Wall. You have 5 minutes.
Thank you. Merci, Monsieur le Président.
Thank you, Chair. I'm one of the founding members of the CCAVC, roughly Community Coalition Against Violent Crimes. You will be hearing from two other members, Mr. André Gélinas and Anis Samson. On the 26th of January, our organization proposed 16 actions to the different levels of government on gun control. Letters were published in two media, and we invite you to read them because there were actions for the federal government as well. On the 21st of February of this year, the Montreal City Council adopted its first action as proposed by our organization. The opposition and the elected officials have agreed to develop a process of engagement and provide a helpline to assist parents. Victims of violent crime and their loved ones are our inspiration. Most of us are responsible parents and who know that children need love as much as discipline to thrive. Discipline will be exercised, with consequences which will be gradual. This type of parent, strongly in a majority in Canada, including those racialized communities, Black, Native, or coming from underprivileged environments. As responsible legislators, they should also adopt laws and sanctions on an appropriate scale of severity, in particular when it comes to serious crimes involving firearms, which is rampant in our Canadian cities. Unfortunately, there are lax, complacent parents who overprotect and pamper their precious children. These precious children will grow up with no respect for others. They'll live with a feeling of impunity and omnipotence. A legislator who is complacent about the serious crimes of criminals in possession of weapons can be assured that there will be a meteoric increase in the number of victims already overrepresented, coming from the same communities as the suspect perpetrators. Bill C5 is in complete dichotomy with the social context of gun violence. Fact: all major cities have shootings that are predominantly caused by gang members. The rate of these shootings doubles every year almost everywhere. Several media reports have highlighted how these criminals enjoy a sense of absolute impunity, which C5 would aggravate. On their social networks, they laugh at the justice and prison systems, often lax, given to them by a complacent justice system. They display their weapons defiantly and with pride. Fact number 2. March 7, 2018, the Ministry of Public Safety and Emergency Prep hosted a gun and gun violence summit in Ottawa. 3 questions come out of this. What happened with the findings and solutions discussed at the summit? 2. The violence situation in Canada improved or greatly deteriorated in the last 4 years. Which is it? Are there fewer illegal guns in Canada now than in 2018? Members of the community are not monolithic in their thinking. Many members of diversity think like Muriel Chatier, Haitian by birth, who is part of our association. I invite you to read her letter, countersigned by other citizens of diverse communities, which speaks of empowerment instead of wallowing in victimization. It's in Appendix E. Fact 4. In Toronto, ideologues have controlled the public safety agenda for 10 years. 450 shootings a year, hundreds of victims. By dint of the amalgamation of police officers, they become disengaged. They do less and less prevention and arrest. Street gang members no longer fear being intercepted, so much so that they keep their guns on them, ready for the next shooting. Gang members have the criminal specialty of pimping. They have no respect for the bodies of girls and women who are there just merchandise. In Montreal, these same ideologues using the same formats as in Toronto. Shootings are on the rise, so are the victims. The police are becoming more and more disengaged. Concerned citizens are calling for a paradigm shift in dealing with gun violence. What if the Canadian legislature would include victims of violence and their loved ones as a center of their considerations? And what if they decided to be more concerned with the victims of violent crimes in so-called racialized community, Black, Aboriginal, or underprivileged backgrounds, than the suspects who are arrested? We should decide to value and trust the humans who wear the uniform. Give less importance to divisive lobby groups, anti-police, the woke, the racialized, and do not represent the pragmatic or moderate opinions of the majority of the population. Listen more attentively to representatives of diverse communities, such as Muriel Chantier, who don't agree with victimization agendas, but rather promotes advocate accountability. Make criminals responsible for their actions and decisions, regardless of community, as responsible parents do with their children, instead of overprotecting criminals as if they were child kings. Refocus the principles of justice. In conclusion, then, if I may, the legislator must better protect the victims who are overrepresented in racialized environments. In Canada, they should have rights and freedoms to life, to health, to security, and this takes precedence over the rights and freedoms of the suspects. Thank you very much, Mr. Chairman.
Next, we'll go to Michelle Sikalasset of the Indigenous Relations, British Columbia Infrastructure Benefits. I think she's in person there, so over to you for 5 minutes.
Thank you. Osiem siaya sialque, Itanishquellowing, Quincy Quetznala. Antas Galusat, Michelle Guerin, Iklaha Kwamasquiam. Respected ones, friends, my traditional name is Galusat Michelle Guerin. I'm from Musqueam Indian Band, and I'm honored to be here today. The name Skalusat was given to me by my elders in my family in our longhouse. Skalus was a warrior who guarded Howe Sound, and according to our stories, he was the first of our people to learn how to write. They chose this name for me because I was the first lawyer in the Guerin family. I often get asked, why did you become a lawyer? I usually respond, I became a lawyer because I'm an Indigenous woman in Canada, and I wanted to be able to protect myself, my children, and my grandchildren. I testified publicly as a survivor in the Missing and Murdered Indigenous Women and Girls Two-Spirited Inquiry. Because I was apprehended, my first son was apprehended from the hospital, spent 1 month in care, was returned to me, and he died of SIDS at 3 months old, so I was robbed of a month with him. Later, my 3 kids were apprehended for 3 days, and when the ministry came for my granddaughter decades later, I was a lawyer and could say, back up. It's important to me to tell you that my mother, Bev Guerin, had graduated from day school with her grade 12, had served in the Canadian Navy, was a secretary in an engineering firm, and my biological father was willing to marry her, but still I was apprehended. I was living in one foster home for 14 years, and at 14 years, I was approached by my social worker and told I had a choice to be adopted by the foster family or meet my family in Musqueam. And I always say I did what any normal 14-year-old would do, and I ran away and lived on the streets for a year. The main basis of my testimony was what I wanted to testify was to share with lawmakers the kind of extreme violence that I experienced on the streets in 1 year, and survived, thankfully, as an example of what our women and girls go through. So a couple points on your bill that I wanted to just try to link to the testimony that I made. When I was reunited with my mother at 14, we didn't reconcile. I think that the pain of losing me and then suddenly being faced with a real live high-risk teenager was very hard for her. I lived with her for 1 month and then was placed in several different foster homes on the reserve. So I've had the unique experience of being placed in several foster homes on and off reserve, and I can attest to the fact that I felt much safer, loved, and nurtured on reserve. Just on the point of racism in courts, going back to my first experience to identify my children when they were apprehended, I was in family court. And my children were apprehended when I had left town to go to a church thing. And anyway, and my husband was in charge. So I came home and my kids were gone. I was to go to court to identify my children, and I was in family court, and the courtroom was called to order. The judge came in, and before he was sat down, he turned to me and asked, "What are you going to do about your drinking problem, Mrs. Sparrow?" To which I replied, "I don't drink, Your Honor." And then he opened the file. A couple points I want to make about policing. I was married to a Vancouver police officer for 30 years. I've been always very supportive of the police. However, I have personally seen and experienced racism by the police. Most issues I have or have had have been with the RCMP. One of the points that I raised during my testimony was to ask for the inquiry to use their researchers, and perhaps you have researchers, because the issue that I'm particularly interested in is how many Indigenous women are arrested, like I'd like the statistics, when they are victims of domestic violence versus how many non-Indigenous women are arrested when they are victims of domestic violence. Because it seems to me, from what I have seen in my communities, that it's standard operating procedure to arrest Indigenous women when they are victims of domestic violence. And it might be called over-policing, but I call it inherent racism. I was also a 911 operator for the RCMP. One day in the radio room, as I sat working, a group of officers were sitting and talking behind me. One of them said, "I don't arrest Indians, I shoot Indians." It was a very shocking and disheartening statement to hear. And I think it's just another signal of some of that systemic racism. And another point, after I returned to the reserve, sadly my mother, Beverly, my late mother, was convicted of fraud, a single mother for writing bad checks, and she was sentenced to several months in jail in the Ocala Penitentiary. And I remember being in court and watching them sentence her. And I sat in the back of the courtroom in disbelief as they sentenced her to serve her time in Ocala, which I thought was a pretty hardcore institution to serve time for a nonviolent crime.
Ms. Scallisette, if you can, your time's up, but if you want to wrap up in the next 10 seconds, and you can hopefully finish off.
Okay, I just got one more point.
Sure.
They're 2 points in one. So I read with interest the proposed legislation that amends the CDSA to require police and prosecutors to consider referring people to treatment programs or other support services. I am a big advocate of this. My my first husband, was pulled over. He had 4 or 5 convictions for drunk driving, but when he was pulled over at the U.S.-Canada border and charged in the States, the U.S. court ordered him to attend a treatment center, and this proved to be life-changing. He became sober. He studied to become a drug and alcohol counselor on the reserve and was very effective in helping others in our community because he brought credibility to the issue. The other point lastly I want to make is that in my current profession, my job is to recruit Indigenous skilled trades workers to become part of our workforce to build large public infrastructure projects in BC under a community benefits agreement. One of the best organizations in BC that is aimed at helping youth either living on the street or aging out of care is a program called Blade Runners. I've met with several youth at friendship centers and talked to them, and their excitement about this program is enormous because they see their peers who are either living on the streets or aging out of the system going into this Blade Runners program, who takes youth and then builds their training and skills up to get them into the skilled trades. However, for those who have a criminal record, they can't access the program.
I'm going to have to, we're
no problem.
over time. I'm hoping somebody will be able to give you some time to finish off. My first witness for the first 6-minute round will go to Mr. Moore.
Thank you, Mr. Chair, and thank you to both of the witnesses for appearing today on this important piece of legislation that could have a profound effect on our communities. I'd like to ask my first question to Mr. Wall. Thank you for your testimony, sir. The government sometimes would have people believe that these are non-serious offenses somehow, and therefore not deserving of jail time. And some of these offenses have been on the books since the 70s. The minimum penalty, certainly through reforms to the criminal code, they remained intact, and many have been upheld in court cases. But I want to bring your attention to a couple: robbery with a firearm, extortion with a firearm, weapons trafficking, using a firearm in the commission of an offense, possession for purpose of weapons trafficking. These sound like serious offenses to me that are at the root of some of the gun and gang problems that we have in this country. What message do you think it sends to the criminal element? And you mentioned the word impunity. I thank you also, sir, for mentioning a word we don't hear often enough: victims. Too often victims get lost, their voice and how they would react to this legislation. We've been hearing a bit from victims, but thank you for mentioning them. But what message do you think it sends to criminals to soften the offenses for gun crimes?
La situation actuelle, merci pour la question, monsieur.
Thank you very much for the question. Well, currently, the situation is that most of the shootings, drive-by or other, are committed by members of street gangs, more or less youth, and sometimes they will even contract out a shooting to a younger member to get them hooked. A lot of media covered these shootings, of course. On social media, we see that the youth are just laughing at the legal system. They're bragging and show off their weapons, posing. That's the situation today. And to adopt Bill 5, which would trivialize the possession of arms for further use in criminal activities, would be to give a wrong message to these criminals. Society feels that we're being too rough on you, so we're going to minimize the sanctions. So this trivializes the possession of these weapons. But the possession of a firearm by a youth, those who have access, almost always gets used in a criminal act. It's not just possession. First, there's going to be shootings, and it'll be shooting at a rival or a foe who come from the same neighborhood, the same community, underprivileged, usually socioeconomic disadvantage. And there's overrepresentation of the victims as well as the suspects. And those who have weapons get radicalized. We take out the suspect and we put him back in the community, and he just can carry on doing what he was doing in his own community or in a neighboring community. It's a very bad signal or message to project. I don't think that this will coincide with the reality as we find it in the streets. Thank you.
Can you comment? There's some misconception that's been perpetrated that somehow this is dealing with minor drug offenses. But when we look at the legislation, the mandatory minimums that are being eliminated from the Controlled Drugs and Substances Act are trafficking or possession for the purpose of trafficking, importing and exporting for the possession of purpose of exporting, and production of a Schedule I or Schedule II drug. That includes heroin, cocaine, fentanyl, crystal meth. Could you comment? You've already commented on the gun crimes, but from the perspective of those that are trafficking, we have a crisis in Canada around drug use in both rural and urban areas. Canadians are dying, suffering. Crystal meth, it's a crisis, but this bill would eliminate mandatory jail time, not for those just in possession, There is no mandatory minimum for possession, but what it does, it eliminates mandatory jail time for traffickers and producers and exporters and importers. Can you comment on that?
Je vais faire ça rapidement.
I'll try to be brief, Mr. Moore. Well, yes. Essentially, the drug scene, it's organized crime that controls the business. But before it gets to the street, there's a number of intermediaries and middlemen. They live a life of crime, and they live in that milieu. So they have no compassion or care to see hundreds and hundreds of people be victimized and get health problems because of the use of those products. So there should be jail time for these people who traffic in drugs.
Merci.
Thank you. Thank you, Mr. Moore. Thank you, Mr. Wall. Now for a 6-minute round for Ms. Briard.
Merci, Monsieur le Président.
Thank you very much, Chair, and welcome to all the witnesses. Thank you very much for being here this afternoon. Now, first of all, Bill C-5 is not intending to soften or minimize penalties. We're trying to reduce the overrepresentation of these minority communities, which are overrepresented in jails. We are hoping that the judiciary will consider alternatives to jail. So my question is for Ms. You've gone through a very rough time. Your life experience indicates that there's been a lot of failures in the system with you. What would you think if the sanction or the penalty, the sentence would be served at home? And what would happen to the quality of life for that individual? Thank you.
Ms. Scalusat, I think that was for you.
Oh, sorry, I didn't hear it. I apologize, I didn't hear it. I'm having a hard time with this.
Est-ce que vous m'entendez?
Can you hear me in French at least? Volume button. 1, 2, 3. Hello, good day. How are you? This is the interpreter speaking. Is it coming through now? Can you hear me in English? Yes, oui. Okay, I was thanking you for having shared your experience with us. You've had a pretty rough time in your life, and your experience illustrates the failings of the system. These sentences, which are served, let's say, as house arrest, what impact would that have on the person who's mixed up in the law? And what would be the impact on the life of a child who would have his sibling or parent serving a sentence at home instead of in jail?
And when you asked the question is, I guess my mind went to the growing problem we have in Indigenous communities with gangs. And it's really difficult when, some of them of our community members belong to gangs. So there's a lot of firearms, there's a lot of issues around that. And and I think that if there was a conditional sentence with people, if it was for a firearms offense or something like that, I don't think that would be appropriate. If there was a victim within the community, especially. I mean, I've been involved in situations where I've been asked to help mediate when there's, if someone reports a gang member for something and then they go to jail and then they're scared they're going to get out and then they're scared they're going to get killed, And I mean, these are people who live 2 blocks away from home. From each other. So it's such a tight community. I think that dependent on the crime. With sexual assaults, I think there would have to be a really fulsome plan put in place into how to deal with that. Maybe if there is preventative and support services that are there for women and children and anyone else who's been sexually abused or sexually assaulted. I think that there's a real effort in communities to try to put more consequences on our members when they have, commit crimes. And if they want to remain in the community, they are always looking for solutions to do that. So I think it's possible.
Thank you. Et dans votre travail.
So in the course of your work, you assist individuals find jobs, you prep them for the workforce. What extra burden would Indigenous clients, what are the obstacles that they face if they've actually served some kind of...
They are targeting youth, high-risk youth, those living on the streets, those coming out of care. We work really hard to... There's some really good programs, and like I said, like this one called Blade Runners is, I always kind of describe it as one that's run on the streets. It's really, really embraced by the youth on the street because they see their friends who have gone into it be successful, get a life, get a career, And I've actually had a lot of young people come up to me during the course of my work and ask if you can help us remove, how could we remove these criminal records? Because I can't access this program with a criminal record. I mean, they got to wait for a pardon and all that. So, I just read with really interest, what's that line you have in here? Would prison do more harm than good?
Okay. And est-ce que vous croyez que...
And do you think that the abolition of these mandatory minimum sentences would perhaps improve their lot in the justice system?
I really like the alternative to jail time that is addressed in there, like the referring to alternatives to jail time. Like if we could try to keep our people out of jail but get them the help they need, and because so much of the social issues that we face in our communities are, you know what they are. And they do shift a bit with each generation. Like I said, now we've got gangs like sort of infiltrating our communities. So that's an issue a lot of communities are dealing with.
Donc, vous croyez que si en place...
So if we were to provide adequate support services, and that would be much preferable.
Preventative support services or treatment programs would be well-resourced. I read background information on this bill, and I'm sorry, I can't remember where, but it talked about perhaps that there was the possibility to develop an action plan with Indigenous groups to provide well-resourced preventative community-based services and alternatives to all. And I think that's fabulous. I mean, I've worked, my work as a lawyer has been primarily at treaty negotiation tables, watching communities get to self-government. We've got enough communities that are capable of running these kinds of these programs, and I think that if it's well-resourced, I think it could be a real shift in them getting some autonomy over some authority or jurisdiction over this issue and dealing with it in their community. Because you tend to find the First Nations communities, when they are part of the creating the solution, it tends to work. So, and the community members, I think, embrace it. It gives it more legitimacy, right? It's not coming from on high. It's like, oh, this is our community's, approach to.
Thank you. Thank you very much.
Thank you, Madame Briard, and thank you, Ms. Cassolet. Now, the next round is to Monsieur Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. And I would to thank the witnesses appearing today, Ms. Scott-Boisset and Mr. Wall. I have a question initially for Mr. Wall. I understand that you're retired from police service. You were supervisor at the Metropolitan Montreal Police Force. I'm sure you've observed over the past few years an increase in gun-related crime in Montreal. And of course, I'm sure that is of concern to a great number of citizens. We hear a lot of it in my neighborhood in North Montreal. When we hear the narrative of police, it's no, we have to maintain maximum mandatory minimum services because they're a deterrent. But it doesn't really. So it doesn't serve as a deterrent in the criminal code anyway. But of these two, I have an opinion. I'm not here to give you my opinion. I'm here to hear what you have to say. I believe it seems that you seem to be leaning that we should be maintaining these MMS, that it serves a deterrent feature. Do you really believe that a minimum sentence, mandatory minimum, would in fact deter individuals from using a firearm in a bank robbery or any other infraction of the criminal code? Thank you for the question. I'm coming through? Yeah? Yes, go ahead. Well, I'd like to get back to basics. The current situation, members of street gangs already feel completely immune and free passage. They're going to be supported in a number of crimes, and impunity was the word that you mentioned. If we examine it a little bit closer, you'll find all sorts of very boastful statements made by youth. They're already laughing at the justice system. They just mock it. And if you have to start at, let's start with the basics. If you possess a gun or a firearm, it's the message you're getting now. It's no big deal. If you want to sugar the pill, you have this right. You're going to be let off easy. I used to be a street cop. I was in Saint Michel. As you know, that there have been a lot of shootings in that neighborhood. And that's the basic feeling there. It's very lax from a policing point of view. And just by removing a little bit, it's not going to help. Minimum sentences for property crimes, for example, nobody would object to that. Remove them. That's okay. But when we're talking about a crime of violence against another person, society has to make a very clear signal, a very clear message, and say you hold them accountable. We don't tolerate that kind of behavior. Well, thank you, Mr. Wall. I don't want to interrupt you, but I'm very short on time. I tend to agree with you. We have very little time. I have another question for you. Now, I know that the police life has been shared by many among you, and as your experience as you said, a street cop, walking the beat, people knew that you know that you were a police officer. You're retired. You're here today. This opinion that we must not abolish mandatory minimums. When we hear it from police organizations or police individuals, what are people telling you? What are the families of victims telling you? And the families of the suspects who end up in jail. The eventual abolition of these minimum sentences. We're talking about firearms here. Well, as I mentioned in my opening remarks, there's some people in our community. We are a coalition of civilians, and we come from a number of various cultural minority groups. We have a Haitian, I mentioned her name. We have other cultural communities, of course, who are represented. So we get together. We're talking about the families of victims in this instance. And what they're looking for is accountability by the youth. They realize there's a laxity in some members of the community, And what they want really is accountability. They want accountability. They're part of society. The family should be responsible. You can't just let your kids run loose. And explain yes, they have rights, but the counterpart to rights is responsibility. And they're not a monolithic group. You have to think of accountability in the youth. Well, the youth who are victims of street gangs, what do they say in regards to minimum sentences? Well, I can tell you about the victims rather than the gang members. Some of these families have lost their children.
We'll get you in the next round. Next, over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I want to start by thanking Ms. Guerin for her testimony today. It is difficult to relive trauma and injustice in public, and I thank her for her bravery in appearing. But it's also important that survivors make their testimony to us, because whenever we've made progress against injustice, it's almost always because survivors have been willing to make that personal sacrifice. So again, my sincere thanks to Ms. Guerin. I'd like to ask her about the differential costs, I guess I would call it, of incarceration for Indigenous and non-Indigenous people. So when Indigenous people are sentenced to a term in prison, can you talk about the effects that has on the family and the community?
Speak from direct experience on that. There was two situations in my family, which sounds like a lot to me, but then when you look at the statistics, you kind of understand how that statistic gets there. Like I said, my mother went into Ocala, and it had severe effect on her psychological and emotional well-being. Just the stigma of it, and then I've had my first husband served many many sentences for drunk driving, like I said. And I used to say, it was really strange because as a family, we had 6 kids, and I'm at home trying to raise 6 kids, and I used to say, and you're in this minimal security club, playing golf, and and I'm struggling to feed kids, and anyway, I do think that I don't know if I'm answering your question, but it definitely has a effect on the families and the communities, right? On the trickle effect of how it affects the kids, community, and stuff. So.
And so in your direct experience that you've talked to us about, what you're talking about is the impact of this systemic racism in resulting in maybe repeated incarcerations for many people from Indigenous communities instead of them getting the treatment and support they need?
Well, yeah, like I said, in Canada, he was charged 4 or 5 times with drunk driving, and it had no effect. It was a cash penalty or weekends in jail or whatever. Then when he got charged on the border of U.S. Canada, he got charged. He had to appear in Blaine court, and they ordered him to go to a treatment center, and it changed our lives, right? And it didn't just change our life. It changed. He became a drug and alcohol counselor, and because he had been such a chronic alcoholic, his credibility in the community to help people was way up. So, I just think the trickle effect from him going to a treatment center had a trickle effect through our whole community, right? So, much better outcome, right?
And just to be clear, in this bill, when it talks about making conditional sentences available, we're talking about making conditional sentences available for only where there's a sentence of less than 2 years. And so I know sometimes there are distortions that get brought into the testimony. We're not really talking about sentences longer than 2 years, which would be the most serious violent crimes. But again, I'm just asking you from your experience, those who go in for short periods of time, do they get rehabilitation and treatment? Like, did your mother get any kind of supportive treatment when she was in Ocala?
None that I'm aware of. None when she got out. Yeah. It had a real detrimental effect on her, I would say, her mental health. She had physical health issues. She had been shot in the leg at one time. And anyway, so, yeah.
And I'm very interested in your talking about Blade Runners, a program I'm very familiar with, and the bar for getting into the program for those with criminal records. But in your personal experience, are there other additional penalties that people suffer when they have a criminal record, like in terms of access to housing or employment? Can you talk about some of those additional barriers?
I don't know. I'm not familiar enough to know whether there is any for housing. And with jobs, like, even in the work that I do, we've had someone that we hired who had a criminal record, and then, interestingly, we had to let him go because of his criminal record. But it was the nature of his criminal record. He was working on a construction crew, and he had been out, he was facing charges of sexual assault on Indigenous women, and then he was on a work crew with all Indigenous people. So there was a level of discomfort, and but to me, I'm just so passionate about this Blade Runner thing because I lived on the streets, and then I know what it's like to look ahead and think, oh my God, what am I, how am I going to build a life by myself? You age out and you're alone, and the young people in this program become a cohort together. They just build each other up, they strengthen each other. So that's why there's other kids on the street wanting to get into that. So I don't know if I'm answering the question properly, but
just very quickly, in your experience, those who need to have the criminal records suspended or a pardon, how easy is it for them to access that process?
We used to have a clinic. UBC had a Indigenous legal clinic in the Skids down in Vancouver, and it was accessible for a lot of people. We often had clients come in asking us to help them fill out pardon papers and those kinds of things. It's just kind of, maneuvering around the system, trying to find the resources. There's not a lot, but at least in BC. So, yeah.
Thank you. Thank you, Mr. Garrison. Next, our first round for 5 minutes will be for Mr. Cooper.
Thank you, Mr. Chair, and thank you to the witnesses for your testimony. I'm going to ask my questions to Mr. Wall. Mr. Wall, you have extensive experience in law enforcement, and in your testimony and in your answers to questions posed by Monsieur Fortin and Mr. Moore, you focused, and the questions were focused on mandatory jail time and more specifically with regards to the firearms and drug offenses. But there's another component of Bill C-5, and that is with a significant expansion of conditional sentencing. The bill, according to the Liberals, is just a matter of seeing that supposedly non-violent criminals can serve time at home instead of behind bars. But when one looks at some of the offenses that would now be eligible for house arrest, they include prison breach, criminal harassment, sexual assault, kidnapping, trafficking in persons for material benefit, abduction of a person under the age of 14, theft over $5,000, breaking and entering a place other than a dwelling house, being unlawfully in a dwelling house, arson for a fraudulent purpose, assault causing bodily harm or with a weapon, and impaired driving causing death, among other serious offenses. What is your opinion of the appropriateness of expanding conditional sentencing for these offenses?
Écoutez, il faut faire attention justement pour faire l'amalgame. Il y a certains.
Well, we can't just amalgamate all sorts of crimes together. Seriousness is gradual and graduated. A second offense, you should up the sanction, and third, and so forth. But you might want to give somebody a break on the first offense. Of all the people I've met as 29 years in the police force, the majority that is usually the silent majority. They really don't understand why we would give a suspended sentence or conditional discharge to somebody in any situation. They don't agree with it, especially if you're talking about an assault, a sexual assault, threats, armed aggression, violent crimes against children, against women, against men as well. That shouldn't be the priority. The priority is not to punish the perpetrator, but to help to assist the victim as well. So we should give the priority to the victims and to make sure that they feel safe and not allow a criminal to reintegrate into society and not be under supervision. Because parole, for example, there's no real supervision. A parole officer might have 60, 70 people as a caseload. And the same thing with conditional discharge. They don't care about that. They're completely indifferent. They take advantage of it. They find it lax.
For that, and I think you raise a very important point about the lack of supervision. And the director of the London Abused Women's Centre, who appeared before our committee last week, said as a result of the expansion of conditional sentencing, specifically as it pertains to sexual assault, vulnerable women are going to be put at risk. Would you agree?
Tout à fait.
Yes, entirely.
Exactement. Si on permet.
If we allow, I remember one specific case about 5 years ago. A victim, a few weeks after the suspect who had been arrested for sexual aggression, she came face to face with him out in a shopping center or something. We allow these individuals to get reintegrated very quickly, and then they continue to threaten the victim, perhaps even seek revenge in some cases. It shouldn't happen in Canada. The rights and freedoms of the victims are primary, and they should be looked at and examined and guaranteed before the freedoms and rights of the perpetrator. If we take a look against property crimes and violent crimes against people, we have to concentrate on those that are violent crimes against the person. They have to have serious consequences, and that's what we want to do with our group.
Mr. Wall, thank you, Mr. Cooper. Next to Ms. Shanahan for 5 minutes.
Thank you very much, Chair. And I, too, want to thank our witnesses for appearing before us today, especially Madame Guérin-Escalusat. I was very touched by your story. Thank you for sharing that with us, and I'm very sorry for the losses that you suffered, and yet in your story there is empowerment that happens with time. So congratulations on being here before us today to share also your expertise and your ideas with us about how we tackle this very difficult problem of antisocial criminal activity within a community. And you alluded to that earlier in an earlier answer, that, of course, community members that pose a danger to other community members, there needs to be some boundaries around that. And so I'd like to get your ideas because, and I'm not a regular member of this committee, nor am I a lawyer, but I would like to hear your expertise on that. Do you have confidence in judges in being able to make the kinds of to do the kind of sentencing that would allow for if someone needs to be in prison for a certain length of time, or for someone to serve out their time in a community setting?
I would say, I have confidence in the judges because I think the implementation of GLADU went pretty well. I think it's something that our community members and those who are facing the criminal justice system are very familiar with. We've got lots of resources to support that process. And yeah, I think that, you know, with that same level of support, I think it would be good.
Well, thank you, because I think that that's what we're trying to say here, is that there's not that there wouldn't be any sentencing going on, or, you know, people would get off scot-free. It's trying to address the person in front of the judge. You talked about your work in training youth, the Blade Runners. I would like to hear more about that program, and in your ideal world, what would you like to see happen to do the kind of preventative program work that would reduce gang violence, for example, in a community?
Wow, that's a tough one. I think on the gang issue, like what can be done, I think something has to be done at the community level, right? I think there's got to be buy-in of the political leadership, of our Indigenous leadership, and I think to some levels there is. It's a challenge, there's no doubt, because some of these gang members are our family members, right? And, you know, it's hard. So, yeah. Sorry, what was the first part of that question?
Well, just what would your vision be? The Blade Runners program, you've been involved with that. And by the way, talking about communities and gang members being a part of all of our communities, all of us from every background, heritage background, we've had our own problems. I'm Irish. I've seen a bit in my time. So,
right.
No. So, but I.
But this is a new
approach.
phenomenon, kind of,
yes,
in Indian reserves, because, well, at least in mine, just seeing the growth of it over the last maybe 10 years, and yeah, it's definitely an issue that needs to be dealt with. I mean, there's firearms involved, right? There's guys, you know, like. So there's guys kidnapping each other. I mean, it's like some of the issues that you're addressing in this bill would, you know, target some of those individuals.
And would you have any ideas around the police force, police forces on reserve? I live near the reserve of Ganawage, and the peacekeepers, from what I have seen, do an excellent job. But there could always be more reinforcement. What do you think?
Well, you know, I sat at a lot of treaty negotiation tables, and there was a lot of discussion about whether to take over like some of these areas of jurisdiction. I think it would take a lot of political will and a lot of resources to do it, to have the communities have what they need to support the work. But I think it could be done.
All right, very good.
Yeah.
Chair,
I would honestly recommend using, you know, and I shouldn't. I mean, but because of the work I've done, I've worked with self-governing communities, and I just think, you know, they've got momentum to be building new processes and systems and to address their issues, and they've often got the revenue as well. So it's, I think, if you wanted to pilot them or something, you know, it might be through some of those communities that really have that strong their political house in order, I always say, and they've got self-government.
Very good.
Thank you. Thank you, Ms. Shanahan. Next, we have 2.5-minute rounds, beginning with Monsieur Fortin.
Merci.
Thank you, Chair. I have a further question for Mr. Wall. I understood your position as to the mandatory minimum sentences, but I'd like to hear what you have to say about the other aspect of C5, that is the diversionary part. There's another part that wants to is there any way that you can bring a youth or a person to justice if there's no alternative options to assist that individual? What the bill aims at is to try to beat the problems of drug addiction or as a health issue, rather than as a criminal activity. The message is, rather than sending the person to jail, send them to a treatment center. We're not talking about drug trafficking in this case. We're talking about personal use, personal consumption, and addiction. Don't you think that a bit too much authority and power is given to a police officer? Don't you think that a judge or a prosecutor should be deciding on the appropriateness of a sanction or a sentence? They are in a better position, perhaps, to judge the case on its merits as a whole. Well, the Young Offenders Act and the issue of diversion has existed for a number of years for these young offenders. So as I said initially in my comments, if the crime is not a crime against the person, well, I think you have to be a little bit more open to these alternatives. As for consuming drugs or possession of drugs, yes, it could well be that an intervention, including social workers and legal workers perhaps, to have mixed teams of support services. One could examine perhaps the past history of the individual and other so-called mitigating factors. I wouldn't be against any of that, but we have to be rational about it. We have to measure something for its value. If it's serious, it's serious. If it's minor, it's minor. And again, if there are consequences to the family. A drug taker has a family, and it'll have effect on the family.
And to Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to go back to Ms. Guerin and where Ms. Shanahan left off, and talking about the interesting idea that you've posed here, that as a result of C5, we might see ourselves ending up in negotiations with First Nations to provide more services like overseeing conditional sentences. And you talked about being at the treaty tables and seeing growing capacity. So could you say some more about that? Again, recognizing that conditional sentences only apply for those under 2 years. Do you believe that there are a lot of communities that could take up this challenge and provide effective conditional sentencing programs?
In my view, yes, I think there is. I mean, I've worked with a number of not just self-governing nations in BC, but also those who are on the path. I always call it a spectrum, right? And so they're somewhere along that spectrum of self-government. Most of them are closer to, like, self-government isn't some moment you just achieve and it's, oh, euphoric, we've got self-government. It's like, so I think there's a lot of capacity in a lot of the nations to do this work. And I think there would be interest in doing the work. I say the only caution I would have is if it was a conditional sentence for someone who was sexually assaulted and both the victim and the, what do you call them, perpetrator, the perp, if they're both from that same community, that could be, you know, it would require, you know, some circles to kind of work through the victim's feelings, I would expect. And we've got lots of strong processes with elders in the courts over in BC that deal with all of these kinds, like deal with all these kinds of sentencing matters. So.
Although, of course, your earlier comment about trusting judges rarely apply sentences of less than 2 years in cases of sexual assault or other crimes involving violence directly. Can I maybe be a little bit more personal here at the end and say, obviously you went through traumatic experiences caused by systemic racism, and you managed to find your way through those and out of those. What do you think the critical factors are for young people who face those challenges in finding more positive paths, and how could we enhance those?
Oh, wow. Well, I would say probably an action plan for the inquiry, Murdered and Missing Indigenous Women Inquiry. I think there's a lot of recommendations made in there that probably would be very helpful if they were implemented. But yeah, it's, I don't know. I mean, I don't know what helped me get through. You know what, actually I should say, what did help me, I think, in the long run, because I became part of a project, I said, called 49 Children Project, where, and I learned this through my Freedom of Information. I did a FOI request for my file from the ministry, which was mind-blowing. And I learned through that process that I became part of a master's thesis project where a social worker took 49 children, returned them to their biological parents, and then they were going to monitor to see what happened. So I always want to say to him, here I am, I'm still killing it. But, it's those kinds of things that are very offensive to Indigenous people, especially you grow up in care and then you find out you became part of these experiments. But
thank you. I really want to thank the witnesses. I want to thank Mr. Garrison for your time. I want to thank all the witnesses. It's always tough reflecting on your own experiences and sharing that in a public forum. Really, our hearts go out to you for doing that in such a great manner. Next, I'm going to suspend for about 1 minute while we do a sound check. Other witnesses to tap back in, and those that are on can get off now, and then I'll resume right back in a minute. Thank you. Just a quick housekeeping. When you have 30 seconds left, I'll raise a green folder, and when your time's up, I'll raise a red folder. So please try to watch for those so I don't have to interrupt you. I'll do the same for members when they're speaking. Each group will have 5 minutes to do an opening statement, following by rounds of questions. If there's something you haven't been able to get out in your opening statement, please do so in the round of questions. I think we have from the Brantford Police Service, we have Robert Davis, the Chief of Police. We also have the Canadian Association of Chiefs Police, Rachel Huggins, Deputy Director and Co-Chair of the Drug Advisory Committee, and Michael Rowe, Inspector and Member of Law Amendments Committee. And then we also have the National Police Federation, Brian Sauvé, President. So all of you welcome. So we'll begin with Robert Davis for 5 minutes.
Good afternoon, members of the committee. Thank you for the opportunity to be here before you today. My name is Rob Davis, and I am the Chief of Police for the Brantford Police Service. I'm proud to be a Mohawk from the Six Nations of the Grand River Territory on which the city of Brantford sits. We are located on the western edge of the Greater Toronto Golden Horseshoe area. I am proud to be the only Indigenous leader of a municipal police service in Ontario, and I've been in policing since 1990, and I have served over half of my career in Indigenous communities, the majority of that being with my home community of Six Nations, where I served with the Six Nations Police Service, as well as with the Anishinaabe-Aski Police Service in Ontario's far north. I have been the Chief of Police for over a decade, having led a small municipal service in Ontario's northwest, Dryden, prior to leading Alberta's third largest municipal police service in Lethbridge, and I now serve in the city of Brantford, a mid-sized city with approximately 100,000 people. I have witnessed firsthand throughout my career, and especially over the last 5 years, the lack of deterrence bail reform has created, specifically since 2019, where we saw bail reform implemented, and it will only be amplified if Bill C-5 is passed and allows for even weaker sentences. Victims of communities will live in fear of gun violence, fearful of retaliation by armed criminals, and people will continue to overdose, many of which will die from fentanyl and other drugs laced with fentanyl that continue to be trafficked with impunity. Certain crimes must result in the removal of the perpetrators from society so that the masses, the law-abiding masses, have a reprieve. Specifically, crimes committed using firearms, the trafficking and production and importation of drugs, and many of the offenses listed in 742.1 sub F that are calling for conditional sentences. My observation has been that crimes committed using firearms are prolific and ever increasing. The victims of crime live in fear. We're seeing the scourge of trafficking, importation, and production of drugs in our cities, and conditional sentences, as suggested, clearly will not work. With that, I will take any questions.
Thank you. Next, we'll go over to Rachel Huggins.
Good afternoon, and thank you for the opportunity to address this committee on behalf of the Canadian Association Chiefs of Police. The CACP applauds the government's effort to modernize Canadian legislation to help address the disproportionate representation of Indigenous and racialized communities in Canada's justice system. As stated in our July 2020 report, we support the decriminalization of simple possession of illicit drugs as an effective way to reduce the public health and public safety harms associated with substance use. While there is support to divert substance users away from the criminal justice system, police across the country have maintained the pursuit of individuals associated to organized crime and criminal networks making large profits, trafficking and producing dangerous illicit drugs. Currently, under the CDSA, mandatory minimum sentences only apply to serious drug trafficking, production, and import-export offenses where public safety is at risk. The use of mandatory minimum sentences is considered when there are aggravating health and safety factors, such as offenses involving the use of a weapon or threat of violence, and production operations that constitute a potential security, health, or safety hazards to persons under the age of 18. We believe the use of aggravating factors applied to mandatory minimum sentences allow police and the court system to focus on the drivers, those driven by monetary gains and putting communities in harm's way, rather than those who commit drug offenses to support their drug use. Therefore, diversion is an important theme of our submission today. Diversion means ensuring that the unique circumstances of a specific offense and offender are considered by a judge when determining an appropriate sentence. It means distinguishing between vulnerable people committing minor offenses who need to be oriented towards pathways of care from criminals committing serious offenses. Diversion also provides opportunities to reduce recidivism and ancillary crimes. It's important to note that for diversion at the police or court level to be successful, there must be an investment in community capacity and resources to support the availability and integration of health and social programs. The basic principles of this modernized approach of aggravating factor guidelines that have been adopted for serious drug-related offenses could conceivably be applied to other crimes, such as those involving firearms. To speak more about this, I now invite my colleague, Michael Rode, to address the committee.
Good afternoon. The police in Canada support the primary objectives of mandatory minimum penalties: to ensure consistency in sentencing, to protect the public, and to discourage others from engaging in similar conduct. For police officers, victims of crime, members of the public, and even the offenders themselves, the circumstances which result in a criminal charge for most firearms offences are often result in a real threat to public safety. Exposure to stress and trauma, which has a lasting impact on mental health, and the erosion of public safety. In my experience as a police officer, the following firearms offences, for which the mandatory minimum penalties are recommended to be repealed, hold significant value when addressing public safety and gang-related violence: the use of a firearm or imitation firearm in the commission of an offence, possession of a prohibited or restricted firearm with ammunition, and discharging a firearm with intent or recklessly. The mandatory minimum penalties assigned to these sections of the Criminal Code create a meaningful legal condemnation of the decision to unlawfully pick up a firearm and reflect the important distinction between offences involving firearms and those that do not. Rather than repealing mandatory minimum penalties for serious offences that have a direct impact on public safety, Parliament could provide the judiciary with additional powers via a legislated clause or safety valve, something other countries with mandatory minimum penalties have, but that is currently absent in Canada. This remedy would allow for the objectives of mandatory minimum penalties to be met, especially for firearms offences that present a real threat to public safety. It would also establish judicial discretion to individually assess each offence and offender to determine if the mandatory minimum penalties are appropriate. Finally, this approach would reduce the need to rely on a reasonable hypothetical to test the impact of mandatory minimum penalties on outlying cases. Imagined offenders or reasonable hypothetical arguments often reduce the significance of firearms offences to a regulatory infraction. This can be frustrating for police officers who see the very real impact of the unlawful possession of loaded handguns, the use of firearms and imitation firearms to commit crime, and the discharge of live ammunition, the impact that these have on the perception of safety within our communities across Canada. In conclusion, the Canadian Association of Chiefs of Police recommends proceeding with the decriminalization of possession of illicit drugs. We also support maintaining mandatory minimum penalties for serious crimes that warrant them, and to add a legislated safety valve that provides sentencing judges with an opportunity to consider the individual circumstances of the offence and the offender to determine if the mandatory minimum penalty is appropriate or if an individual could be diverted away from the justice system toward an alternative pathway. Thank you very much.
Thank you. Thank you, both of you. Next, we have Brian Sauvé from Surrey, BC, from National Police Federation.
Oh, good afternoon. Thank you for inviting me to here today. I'm Brian Sauvé, a sergeant in the RCMP and current president of the National Police Federation, the certified bargaining agent representing close to 20,000 members of the RCMP. I'd like to begin by acknowledging that I'm speaking today from the traditional unceded territory of the Algonquin Anishinaabe people. Bill C-5 takes several important steps in the right direction. This legislation acknowledges and supports practices that are happening today, such as the discretion of police officers to refer offenders to diversion and treatment programs. Legislative support for these practices means enforcement across Canada will become more consistent. However, the legislation lacks clarity in many areas. I'd like to address three main areas of concern. First, police resources and discretion. We support the use of police discretion and alternatives to our incarceration for lower risk offenders who would benefit from treatment and rehabilitation. Diversion to these programs is a valuable tool to police. Our members acknowledge this key role, but government must provide the necessary support and resources to make sure that police officers can do it effectively. Even after this bill is passed, police officers will still need to enforce laws against those involved in drug smuggling, drug trafficking, drug production, and the link between weapons and drug trafficking still needs to be addressed. Drug trafficking exacerbates the opioid epidemic, which continues to impact Canada's health network and police services. For perspective, in 2020, the opioid crisis claimed the lives of 6,306 people in Canada, and that's equivalent to 17 deaths per day. The government has invested hundreds of thousands of dollars to combat this crisis, but the numbers continue to rise. To address these important issues, we will need a whole of government approach. Second, program availability. Bill C-5 needs to be accompanied by an expansion of investments in programs such as addictions treatment, rehabilitation, and diversion. The need for greater support for social programs exists across Canada. However, the gap that police officers and community members face in rural and remote areas needs to be urgently addressed. According to a Justice Canada report, 48% of surveyed police agencies have a pre-charge diversion program for youth offenders. However, 66% of rural and small town police agencies have no pre-charge diversion program. This gap is further exacerbated in Indigenous communities where the lack of a diversion programs aggravates overrepresentation in the justice system. Successful diversion programs need consistent, ongoing funding and meaningful evidence-based oversight to ensure effectiveness. Meanwhile, police officers require the time, the staff, and the resources to be able to refer cases to these treatment programs. Third is border integrity. Bill C-5 strikes down some mandatory minimum penalties related to weapons trafficking and firearms offenses. This is inconsistent with the expressed intent of the government to reduce firearms violence in Canada. The legislation maintains mandatory minimum penalties for offenses such as weapons trafficking, the production of automatic firearms, and murder or manslaughter involving the use of a firearm. However, tackling criminal activity requires strong measures against criminals that threaten vulnerable communities, especially criminal activity that funds and empowers gangs and organized crime. Bill C-5, unfortunately, does not address these problems. The removal of mandatory minimum penalties requires additional deterrence measures to address criminal activity, such as providing more resources to stop the import of illegal drugs and firearms at the border. The NPF calls for increased funding to the RCMP Border Integrity Program and the creation of an investigative firearms smuggling unit. In conclusion, to achieve its primary goal, this legislation needs to be backed by increased funding in 3 areas: evidence-based and effective social programs to ensure that the root causes of drug use and firearms trafficking are being adequately addressed, sufficient police resources to ensure that members have the personnel and resources to meet the increased workload created by this legislation, and support for border enforcement to address the import of illicit drugs and firearms. Thank you, and I'm happy to answer any questions.
Thank you, Mr. Sauvé. Now we'll go for our first round of questions. And just for clarity, any of the witnesses that don't have an interpretation, just to let you know, there's an interpretation function on the bottom of your screen if you're doing it remotely. And in the house, you can set your the little headset that's in front of you to floor, which is whatever language is being spoken to, or English or French, and then you can turn up the volume and use those. I know that's probably been advised you already, but just letting you know in case there's any issue. I'll go over to Mr. Brock for 6 minutes.
Thank you, Mr. Chair. Thank you, witnesses, for your attendance today. To Chief Davis, given your decades of police service in numerous cities and towns, various provinces, and Indigenous reserves in both southern and northern Ontario, I would like to hear your opening thoughts on the impact of policing and community safety if the current version of Bill C-5 passes without amendment.
Thank you for the question, Mr. Brock. As I mentioned in my opening, there's already frustration from the victims of crime with bail reform. The perception from the victims is that the criminals' rights supersede those of citizens. With C-5 and the proposed changes, now we're going to see the sentencing become a joke, to be quite candid. The victims of crime will not, let me rephrase that. The victims of crime will have the perception that their rights have once again been superseded given to the rights of the criminal. Also, I'm very concerned that what we're seeing with Indigenous populations, my experience on reserve and my experience off reserve with urban Indigenous populations, there's already a layer of distrust with the police and the justice system, and we have to work really hard to get people to cooperate with us. And I've experienced this, where when the justice system is perceived to fail them because the criminal's rights supersede those of the victim.
Thank you, Chief. I'm going to move on because my time is limited. Okay. Bill C-5 removes limitations placed on the use of conditional sentences of imprisonment. Offenses such as sex assault, arson, crim harassment, kidnapping, trafficking of persons, abduction of persons under 14, and prison breach are now open for consideration. Can you comment on how this will impact community safety in the context of the offenses I just read out? I'd also like to hear your opinion on the deterrent impact of conditional sentences and the reality on the street when it comes to compliance and enforcement of those orders.
So again, just to reiterate that the criminals are going to operate with impunity, that we already have weak bail conditions. Those will be exacerbated by weak sentences. Sentences, essentially, conditional sentences are so they can serve at the comforts of their home. That's not a sentence. They'll be able to operate. And when you look at the list of 742.1 sub F, it's perplexing that criminal harassment, we heard the earlier speakers talk about the intimidation, the harassment that goes on by the criminals, sexual assault, kidnapping that we see tied to the drug industry with firearms being involved, the trafficking in persons. If we're serious about human trafficking, we're going to allow a house arrest to happen for a human trafficker? It makes no sense.
Opponents of mandatory minimum penalties argue that they unjustly limit judicial discretion, have little or no deterrent effect, and can result in disproportionate sentencing. The government argues that we should trust our judges across our country to do the right thing, to hold offenders accountable while at the same time promoting community safety. I'd like to hear your thoughts based on your experience both on the judicial issue and the deterrent impact of eliminating mandatory minimum penalties, particularly within the firearm context.
First, with the judicial impact, the question about the trust the judges and there'll be consistency. There is no consistency. My experience from Southern Ontario to Northern Ontario, night and day. My experience from Ontario to Western Ontario when I was serving in Alberta, night and day. So the belief that there be consistency amongst the judges is not founded in the reality I've observed throughout my career. With respect to the impact of turning sentences into conditional sentences, again, I think the justice system is going to be brought into disrepute. People will operate with impunity. The victim's rights are going to be given away for the rights of the criminal. One last point.
Yep.
Is the enforcement of conditions requires police resources to do those compliance checks, which we're not funded for. And if we're going to have house arrest, there has to be a rigorous compliance program, which at this point, most police services, I believe, would struggle to have the resources to do an effective job of that compliance check.
Thank you, Chief. I've got basically a minute and a half. The government has argued since introducing the bill that mandatory minimum penalties have the disproportionate impact of the over-incarceration of Indigenous offenders, both males and especially females and other marginalized populations. Given my prior legal career as a Crown attorney, I am particularly cognizant of the over-incarceration issue. I'd like to hear your thoughts on this and the efforts, particularly in Ontario, of the impact of the Indigenous People Court, or commonly known as GLADU Court, in under 1 minute, please.
There's a time and place for GLADU. GLADU considerations do make sense, and I support GLADU considerations for the offenses that are lower in nature. But when we're talking about using firearms in the commissions of an offense, the trafficking of drugs, the importation of drugs, the production of drugs that impact communities, those are crimes for which GLADU, it makes no sense to apply them, especially when the victims are Indigenous as well. And so there's a time and place for GLADU, but for the offenses that are suggested to have the minimums removed, it makes no sense.
Very quickly, what is the perception of law-abiding Indigenous residents on the Six Nations of the Grand River as it applies to Gladue Court?
Again, I don't speak for Six Nations. It's the largest community based on population, so there's varying opinions. My experience when I worked there and dealing with Indigenous people from Six Nations in Brantford
Go ahead.
is much like I said. There's a time and place for Gladue, but if people committing the crimes are Indigenous and it's impacting our people, then the Gladue considerations, they're moot because they're harming our own people.
Thank you, Chief.
Thank you. Thank you, Mr. Brock, and thank you to our witness. To Ms. Diab for 6 minutes.
Thank you very much, Chair, and thank you to all our witnesses coming with us this Friday afternoon as we continue to hear testimony on this, on Bill C-5. Mr. Sauvé, I'm going to direct my first question to you. I met this week, it was part of a lobby week, and I met with 2 sergeants from the Halifax Police Association. We had a great discussion and conversation that included a discussion of mandatory minimum sentences. They gave me a pamphlet, and I'm not sure how many MPs met, but and it had 3 recommendations, one of which, when I read it, tied into exactly Bill C-5, and I told them that. And it dealt with the mandatory minimum sentences. So, and the pamphlet talked about, and they didn't know anything about Bill C-5, the ones that I was meeting with. They were lobbying us, obviously, that's what they do. It's called Lobby Week, government to exempt officers and to allow the mandatory minimum sentences to allow judicial discretion when officers are faced with when they discharge their service weapon in the line of duty. And so my question to you, would you argue for that same change? And can you discuss the importance of flexibility to judges to craft sentences, I guess, that fit whatever unique circumstances? And this one, I really found it, given what we're doing, very important, so I'm going to ask you that question.
Thank you for the question. I am familiar with the position that they have lobbied you on. And essentially what we're talking about is police officers, we entrust them with a lot of power and authority in Canada. And, Section 25 of the Criminal Code gives them essentially the ability to take a life if the situation warrants it. And unfortunately, that life may be taken with the use of a firearm. Right now, judges have very little discretion with respect to if a member of a police service takes a life using a firearm, that is use of a firearm in the commission of an offense, should that interaction be deemed criminal in nature by any civilian oversight body, and you go to a judicial proceeding and that member of that police service is found guilty, there is no discretion. Mandatory minimum must be imposed. So the ask to impose some judicial discretion for police officers or corrections officers or those working the border who are armed, should they end up in a lethal interaction and ultimately end up in a proceeding where they're found guilty, that the judiciary have some discretion to not impose a mandatory minimum sentence on that member of that police service is what they're asking for. And yes, I would support that 100%.
So take that a bit further, and I think I may have heard this, but I just want to double check. Would you support then more flexibility for judges to use their discretion in other offenses, depending on the unique situation? Remember, we're talking mandatory minimums, and these are for offenses. Generally we're trying to, and as well for conditional sentence orders, I guess, as well, where the term is, again, less than 2 years imprisonment. And for those that don't pose a threat to public safety, whether it's police officers or any members of society, whether it's an Indigenous individual, somebody from the African community, or a white, black, man, black, woman, whatever, I guess, is what I would like to know.
Well, I think we have to delineate the two. So on the one hand, we're talking about police officers who are trained and highly regulated within their use of force continuum, and we're talking about specifics, and they are rare, where a police officer may get convicted or charged for a use of force incident using deadly force, such as a firearm. That is where that particular lobby perspective is, to allow the judiciary to use discretion, because we trust them to use that authority on a very, very rare basis, and it is extremely rare that that is used in Canada. When you start talking about broader perspectives, it is a bigger discussion. And as I mentioned in my opening remarks, we really are opening up a can of worms that touches on many of the social safety networks that our communities across Canada, both large and small, rely upon, to whether it's overrepresentation within the justice system or whether it's treatment programs. There needs to be a consistent approach in every community across Canada if we're going to look at the reduction of or elimination of mandatory minimum penalties.
And I hear you on resources, and I hear you on the need for effective social programs. I think we hear that, and we agree with that. Thank you. Is that green? Does that mean my time is up, Mr.? Okay. Thank you very much.
No, you have 30 seconds.
Okay. So I guess my final question: can you talk about diversion in appropriate circumstances, and do you think that's good for the individual, their family members, and their community?
In my experience, when we're not talking about violence and we're not talking about firearms, diversionary programs and treatment programs are extremely effective, and they are supportive of the rehabilitative nature of Canada's justice system.
Thank you very much.
Thank you, Ms. Diab. Now to Mr. Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair, and thanks to the witnesses appearing this afternoon. It's very much important, and all points of view are important to us. For those who haven't been told, there is interpretation available. Choose the right channel, settle the volume, and I will speak in French. So, Mr. Davis, I was very interested in your testimony, and yet, towards the end you were saying the way that C5 is drafted currently would perhaps give victims of crime the impression that they're being sort of set aside or neglected. And I react to that because I have faith in our judicial system. I think that judges, if not always and 99.9% of the time, render appropriate sentences, and there's a process appeal in any case. So I trust the judicial system. But the impression that the society has of the justice system is very concerning to me. People have to feel that they've been heard. And on the legislators' part, that's our job. We have to be attentive to the concerns of the public. So, did I interpret you correctly that if we were to leave a certain margin of maneuver to the judge, maintain MMS in any crime with a firearm, but allow the judge to set aside a minimum mandatory sentence in certain extraordinary special circumstances, would that still calm perhaps the public impression that we have to maintain a hard line and maintain mandatory minimums?
Just repeat the tail end of the tail end. There's a gap.
J'ai dit, est-ce que ce...
Surely, in your opinion, if B5 was adopted with a few modifications, if you will, and if we would allow the judge to set aside a mandatory minimum sentence, and I'm talking about firearm-type crimes, that you maintain MMS, but you allow the judge to set aside, to exempt imposing a mandatory in exceptional circumstances. Now, if that were the case, if the bill was amended this way, would this serve justice, and would the population feel more confident, perhaps, or at ease with that?
The question, I believe, if the situations were exceptional, and that was conveyed clearly to the Canadian public and to the victims of crime as to what makes it exceptional, then there's I believe that's reasonable.
Et je vous remercie, Monsieur Davis. Et je voudrais poser.
Thank you very much, Mr. Davis. I'd like to ask the same question to either Madame Huggins or Rode. I don't know who wishes to answer, but according to your experience, would such a adaptation of the law, modification, we trust a judge to arrive at a correct decision, and would it help?
Suggested the use of a legislative clause or legislated safety valve, as it's known, to allow judges in exceptional circumstances to examine the offender and the offense in question would allow the establishment of a fit and proper sentence for serious crimes, specifically those with firearms, allow the public to know that the Parliament, the government, has set a fit and proper sentence, but then also allow exceptional circumstances to be considered and provide judges with legislated discretion that would allow them to be able to examine each, the individual offender in those exceptional circumstances.
Merci.
Thank you. In the same line of thought, we, of course, would like to reassure the public. Let's talk about arms trafficking that goes through Indian reserves sometimes. And then you have a unit, a specialized unit. Usually it's a joint force, RCMP, Ontario, SQ, American Police, to try to, choke off that kind of traffic. If that were the case, would that reassure the public and perhaps counter this negative approach of feeling about C5? Mr. Davis?
I think it would definitely help. One of the struggles that I've experienced both in my time in Indigenous policing as well as in municipal policing is that those task forces are typically administered and run by the RCMP because of the multi-jurisdictional, cross-border, interprovincial nature. And it goes in ebbs and flows where there's a lack of funding to allow the municipal police services to second members. And from my previous experience and my current work, where I work very closely daily with the Six Nations Police Service, Indigenous policing is still treated as a program in this country. There needs to be a commitment from the government to actually make First Nations policing, Indigenous policing, more than a program, to make it that those services know that they have the resources to take part in such task forces.
Merci, Monsieur Davis.
Thank you, Mr. Davis.
C'est pas 30 secondes?
Not 30 seconds? 6 minutes.
10 seconds to be exact. Now I'll go over to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I want to thank Chief Davis and the National Federation of Police for bringing the resource question onto the table here, that it's simply not enough to pass law, but we have to make sure programs are properly resourced. But I want to start with a question to Mr. Rowe from the Canadian Association of Chiefs of Police on the idea of a safety valve for mandatory minimums, something which I personally favor. Looking at Bill C5, it's difficult for me to see how that can be added into this bill. Have you had any discussions either amongst yourselves or with the government about how we might get such a safety valve into C5? Because that would deal with all overall judicial discretion, and the bill's a bit narrower than that.
Yeah, thank you, sir. I did note that in the United Kingdom, where they have had mandatory minimum penalties for firearms offenses for quite a while, in which their mandatory minimum penalties are, in fact, more severe or more strict than what Canada is proposing, but have been successfully upheld in their courts. They have been successful using this idea of a safety valve or a legislated clause. So I do believe there is precedent for it to be applied and for it to function well in the courts. And as I mentioned in my statement, the other benefit would be that it would allow the individual offenders and the individual offenses to be examined rather than having to rely on the reasonable hypothetical or the imagined offender in order to challenge the compliance with the current mandatory minimum penalties against the Charter.
Yeah, thanks for that. It is, of course, for me, very persuasive, but we have a narrower bill in front of us, so it's kind of difficult to imagine how we get there from here. I want to turn to Mr. Sauvé and talk about that gap that he noted in the existence of diversion programs in rural, remote, and Indigenous communities. And I guess my question, Mr. Sauvé, is how we fill that gap. Who now funds most of those programs? And having noted the lack of programming, do you have any suggestions about how the government could make sure that gap gets filled?
This is a big discussion, and when I mentioned in my opening remarks, whole of government, we're not just talking federal, right? Obviously, because your healthcare systems are run provincially, and all of those challenges with respect to federal and provincial funding, not to mention access municipally. Just yesterday, I was talking to some legislators up in one of the territories, and there we were talking about the challenges to healthcare simply just in rural and remote communities, not even broaching the subject of treatment and diversionary programs. So for us, what our members are seeing, and the majority of our members in uniform out in Canada are in smaller communities outside of the Burnabys or the Surreys and the Edmonton areas, they are exactly that. The government representatives on the ground might be Canada Post and the RCMP. If you're lucky, you have both. So our members actually end up working with the community. Sometimes we have a story coming forth from one of our members who was a chef before they joined the RCMP, and started cooking classes for underprivileged youth, bringing in food and showing them how to sustain for themselves. So that kind of example is there. It's just off the cuff, off the side of a desk, but it has an impact to the community ahead of time. So how do we get there where everyone in Canada has access to the same types of program? That's a really big discussion. I'd love to be a part of it, but I think it's more than just this table.
And just following along on that, in the experience of your members, is there a differential impact of sentence of incarceration when it comes to rural, remote, and Indigenous communities than for those in urban communities?
Yes. Hence why in the opening remarks we mentioned that, the lack of access in different smaller communities to pre-charge diversionary programs, or the ability for treatment and diversionary programs. Sometimes, just talk about Mental Health Act apprehensions. Sometimes for our members, that means an apprehension and a flight to the closest healthcare center where there's a psychiatric nurse. We could be talking about hours of police resources just to bring someone to the care that they need. Now you have to think about other pre-charge or charge diversionary programs and funding in those rural and remote communities. Eventually you get to a point, and I think that's where we are now, the systemic problem is that we're ending up with overrepresentation of those underfunded or neglected communities in Canada into the justice system. So we need to do better at the front end versus the back end.
And I guess you would say the same thing applies when it comes to those who've been released from custodial sentences, that there really aren't appropriate facilities in smaller communities to help reintegrate them into the community.
It goes the conversation even further is when we start talking about rehabilitation post-incarceration, and are we looking at job training? Are we looking at education and vocational training? How are we funding that to make that person who has served their sentence a productive, happy member of whatever community they're part
of? Well, thank you very much. I think we're just about out of time.
Thank you, Mr. Garrison. Next, we'll go to, and I'm just for the interest of time, so we can have a couple minutes at the end, I'm just going to condense the next ones to 2 4-minute rounds and the last two to 2-minute rounds, if that's okay. Next, we'll have Mr. Morrison for 4 minutes.
Thank you, Mr. Chair, and I want to thank all the witnesses for being here today. I do have one question, I think more for Mr. Sauvé, representing 20,000 police across Canada, many rural, really remote, in some cases, understaffed. One of the expansion of conditional sentences clauses is for someone can get a conditional sentence order who assaults a police officer causing bodily harm or with a weapon. I'm just wondering how that would resonate throughout the Royal Canadian Mounted Police across Canada if, in fact, C5 approved that.
Well, I think our membership, first off, would say try and find a crown prosecutor that will lay the charge of assault a police officer on the one hand. So there is that. Secondly, actually going to trial and having that, it's in today's underfunded and overtaxed judicial system. I don't even know if we would ever get to a trial. I don't even know if we would ever get to a point where a sentencing is there. However, yes, the morale issue of just the perception of removing that would not go over well.
Okay, and maybe, one other thing too, and I know from your policing experience and of course representing a large group of diverse police officers, that lots of times we seem to, and we have even on this particular C5 bill, focus a little bit on offenders when in fact really our priority, especially as representatives for Canadians, whether it's in my riding or whether it's across Canada, our focus should be on victims. And I'm just wondering, since you, in your experience, I know as a former police officer, that you always see the aftermath because you're dealing with the victim first. And then, of course, your job is to investigate and, of course, charge if charges are there and arrest someone. How do you think, from the people you've spoken to and that people have felt, if you have talked to them about C5 or about some of these removing mandatory minimum penalties, how do you think the victims, if you've talked to them, if they've given you any opinion on where they stand?
I think from a global perspective, we have to look at where Canada's justice system is focused. And I did mention it in one of my other responses, Canada's justice system is focused on a rehabilitative setup. It is not based on incarceration, it's based on rehabilitation. So if we're going to look at an incarceration-based system, then okay, then we're going to have one person's rights exceed the other person's rights. What we have to remember is that up until a point a person is found guilty in a court of law, they have the same rights as everyone else because they are only accused of a crime. Now, I'm not a lawyer, I'm not a constitutional expert or anything, but the judiciary is there to impose fair sentencing based on the facts of the crime. So can we draft legislation which empowers one party to have greater rights than the other party? I don't know, and I can't give you an answer on that one.
No problems with that at all. I also want to maybe talk, I probably have 30 seconds left. I know the RCMP and I've worked with restorative justice, so I'm just wondering, don't you really think that we should be focusing on that crime prevention, not so much crime reduction, but crime prevention? I mean, we talked about Blade Runners, another program we have, in Canada. Should not we, especially in law enforcement, be focusing on that and putting resources into that?
I agree with you. I did spend a lot of time with restorative justice folks in the early years of my career, and I 100% support it. I think it's a fantastic program, whether it's a pre-charge diversion program or even a post-charge diversion program, or even just restorative justice to eliminate the charge and sit down and have that discussion.
Thank you.
However, they have been unequally applied all across different jurisdictions with inadequate funding and no effective mechanism to ensure that they're effective.
There is time's out. Next, if I can have Mr. Naqvi for 4 minutes.
Thank you very much, Chair. I'm going to go to Ms. Huggins and talk a little bit about what you were speaking of in terms of diversion. I believe it was in CACP's July 2020 statement that was addressing the opioid crisis, that the organization called for alternatives to criminal sanctions for simple possession of illicit drugs and the adoption of a more health-based diversionary approach. In your view, does Bill C-5 answer that call? Will it help address the opioid crisis that Canada is going through?
Thank you for the question. With regards to Bill C-5 and the drug piece, it's very much reflective. So the aggravated penalties that are associated, the aggravated factors that are associated to the mandatory minimum penalties actually align with the perspective that the CACP is taking, in that it allows both the police and the courts to focus on the more serious factors when it comes to trafficking, importing, exporting, and production. So the way the aggravated factors line up and looking at things like when there's violence or the use of weapons or the fact that it's production when there are a child involved, those are the kinds of aspects that make the current state, that modernized approach of the bill, much more effective. Mandatory minimums are there, but they're being used in a very specific way. And so we really do support the way it is currently right now with those aggravating factors versus just having no mandatory minimums. We think that the way it is articulated actually matches with allowing both the courts and police to divert individuals into pathways of care.
I was quite pleased when I saw CACP's position on diversion and making the point that government should look into passing law that would allow for more discretion for police and prosecutors to divert people out of the criminal justice system, those who have been found to have simple possession of drugs. What led to CACP to come up with that position? I mean, it's something not one associated with policing partners to come with that position, and I thought it was quite progressive. And can you speak to a little bit of your research and analysis that went into making that recommendation?
I think that it's very much based on the fact that we have been in an opioid crisis for the last 4 to 5 years. We are seeing a large number of deaths, and enforcement has not effectively addressed the issue. And we recognize that from the opioid crisis that these individuals who are dying or who use drugs or who have to be resuscitated using naloxone by police need other opportunities to find the right pathway and the right kind of health care and support services that they need. And that's not going to come from the policing perspective. And so that really encouraged the CACP to recognize that this is a health crisis and that police are there to support, but it needs a health focus.
Do you think...
Thank you, Mr. Naqvi.
Sorry, thank you, Chair.
Apologize. Next, we'll go for our last 2-minute rounds, beginning with Mr. Fortin for 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. I only have 2 minutes, so I won't keep on the way I was going, but I have a series of questions, and I'll go with Ms. Huggins. I think you heard my earlier comments. Could there be any room for agreement when we talk about sentencing to gun crime? Let's stick to just gun crime. If we were to maintain MMS, adding perhaps a provision allowing the judge to exonerate or not use in exceptional circumstances. Do you think that that would be a useful and acceptable compromise?
I do think that that would be acceptable. I think that we've used it with regards to drug offenses, and I think that similar provisions could be provided for certain firearm offenses. Not necessarily all, but I think that that is a discussion that should happen.
Merci.
Thank you. A further question, same witness. I spoke to Mr. Davis about fighting organized crime, or rather arms traffic on the borders, and perhaps the establishment of a joint task team to trying to put an end to this traffic. It's almost always at the border. Do you think that a joint mixed task force, OPP, SQ, Ontario, RCMP, Peacekeepers, and American police forces, do you think that would help in reducing, or if not eliminating, gun trafficking? Because it is a big concern.
I think I'll have to ask my
Very
colleague to
briefly.
answer that question.
Very briefly, sir, that's what I've done for the majority of my career, is lead joint task forces for gang violence, violent crimes, firearms offenses. That's where the base of my experience lasts. And it is an extremely effective way to deal with complex crimes, such as cross-border drug trafficking. If you bring together multiple people from multiple agencies, you get a variety of experience, and it's a very effective way of dealing with complex crime.
Thank you. Thank you, Monsieur Fortin. Last 2 minutes to Mr. Garrison.
Thank you very much, Mr. Chair. I'll just ask one quick similar question to Mr. Sauvé. When it comes to fighting the import of illegal weapons at the border, is the problem really sentencing or legislation, or is it the lack of resources applied to this problem?
Bluntly put, lack of resources applied to this problem. We share the longest undefended border in the world with the largest manufacturer of small arms. So if we're going to take gun safety seriously and gun trafficking seriously, we need to look at how we're resourcing that particular border.
Thank you very much, Mr. Chair. I'm prepared to end my questions now in the interest of time.
Thank you. I want to thank Mr. Garrison, always mindful of time, and probably our best member when it comes to giving away time to others. I want to thank all the witnesses that have come today. I want to thank you. You've given very valid and important testimony today. So you're free and dismissed. If you want to stay around, you're more than welcome to stay. We just have a couple minutes of community business, committee business. So those that want to log off are more than welcome to log off. Members, it's just about member travel. I think we have to give our submissions to liaison committee today. It's been shared around with everyone. I believe the first step is giving this of where we want to travel, and it's a bit broader than it's better to be broader than narrower, is what I've been told. And once they decide, if they decide liaison committee that this travel will be considered, then we have to produce a budget for it and give that back. Am I right, Mr. Clerk? Is that how it works?
Yes.
Yes. So. Can I see any debate on this or any raise of hands? I think I've canvassed mostly the vice chairs and Mr. Garrison on this. Are we in agreement on this? Nods, thumbs up. Mr. Moore, we're good? Perfect. Thank you, Mr. Clerk. Do we need anything else from us?
No, all good for me.
Perfect. All right, have a good weekend and see you back next week. Take care. Meeting is adjourned.